Very good morning. I hope all of you are doing great. So we are here for session 3 on additional topics for CA Foundation Law, which are applicable for May 2024 examination. June, to be very precise, June 2024 examination. Good morning, everyone. So if you remember, in yesterday's session, we had started our discussion on special contracts, and first thing we completed was contract of indemnity. So the next topic that we started was contract of guarantee. Under contract of guarantee, we understood what contract of guarantee was. We said contract of guarantee is a contract whereby one party promises to repay the liabilities or perform in case of failure by third party. So the party who is promising was called as surety. The party to whom the guarantee was given was called as creditor, and party on whose behalf the guarantee was given was called as principal debtor. We also understood various circumstances where contract of guarantee types, different types of contract of guarantee was discussed. After which we also discussed difference between contract of indemnity and contract of guarantee. Then we proceeded ahead to discuss various scenarios when surety shall stand discharged. While speaking about the types of guarantee, we said that there are two types of guarantee. One is specific guarantee, one is continuing guarantee. If a guarantee extends to a specific transaction, we called it as specific guarantee. Whereas if the guarantee extended for a series of transactions, we would call it as continuing guarantee. Now, in case of specific guarantee, once the debt is incurred, there was no possibility of revoking the particular guarantee. He continues to be liable till the debt is settled. Whereas on the other hand, when it comes to continuing guarantee can be revoked as to future transactions. With respect to future transactions, continuing guarantee can be revoked. This was the principle we understood. Similarly, when the surety dies, for the future transactions after the date of death, surety will not be liable. For the transactions done till the date of death, surety stands liable, or surety's estates will be liable. Similarly, when there is a novation of the contract, surety stands discharged from the earlier contract. In the new contract, if he is a party, he'll continue to be liable for the new contract. Then we also discussed about certain conduct of the creditor, which may discharge the surety from the contract. And then we also discussed certain circumstances where contract of guarantee itself becomes invalid, invalidation of contract of guarantee, misrepresentation, concealment of fact, and where the surety has put a condition that he will join as a surety only if a co-surety joins him, and if the co-surety does not join and creditor acts upon, the contract of guarantee is not valid. This is what we discussed in the yesterday's session. Now, continuing further, we have to discuss about what are the rights a surety enjoys. When a person gives a guarantee to another person, what are the rights he enjoys as against that other person? So since surety is in a position where is going to perform contract on behalf of principal debtor, as against principal debtor, he has certain rights. Sometimes what he does is he pays the debt on behalf of the principal debtor. That time, certain rights he can enjoy against creditor also. And whenever there is a co-surety means another person who is appointed as surety or who is giving a guarantee along with one surety. Such persons are called as co-sureties. Against such co-sureties also, there are certain rights which can be enjoyed. So Topic wise, we need to discuss all these things now. So let us try to analyze this. First thing is, against principal debtor, there are two rights that a surety enjoys. One is right of subrogation, the other one is right of indemnity. Right of subrogation. Subrogate. What exactly do we mean by subrogate? Subrogating means you taking over the position of another person is called as subrogation. When you step into the shoes of other person, or when you get the rights of other person, I will call it as subrogation. That is called as subrogation. Good morning. Good morning. We have people joining now. Very nice. Good morning. Good morning, everyone. Subrogation. Subrogation means taking over someone's place or to put in the place of another. That is what is called as subrogate. Let us try to understand what exactly subrogation means. So, we already know that this is a contract between, there is a principal debtor, there is a creditor, and there is a surety. Surety promises creditor. Surety promises creditor. Now, if surety pays the debt, if surety pays the debt which was actually primarily to be paid by principal debtor, on his failure, if surety pays it, automatically what happens is, for the as against the principal debtor, surety becomes the new creditor. This creditor is gone, surety becomes the creditor. Surety becomes the debtor. Surety will step into the shoes of creditor. This is called as right of subrogation. This is what is called as subrogation. The surety shall be entitled to all the rights which the creditor could claim against the principal debtor. Now, how does this work? Let us say creditor has given a loan to principal debtor, against which a property of principal debtor is given as security. Property of principal debtor is given as a security. That means if creditor, surety is also there. Along with surety, a property of principal debtor is given as a security. Now, technically speaking, what happens is, suppose if principal debtor fails to pay the debt, principal debtor fails to pay the loan, creditor can auction this property. Practical scenario, I'm saying. Creditor can go to court, bring an action, and through the action of the court or through the order of the court, creditor can put this security or property into auction. And once he goes for auction, from the proceeds of the auction sale, he can settle the debt. This is the basic rule how the security loan works. Collateral, loan with collateral works. Now, when surety pays the creditor, surety makes the payment. Automatically, this security which was bestowed with the creditor or which was on which creditor had a right gets shifted to surety. Gets shifted to surety. Now, surety has the right. Same right what creditor had. Creditor had the right to auction this particular security. Now, surety also gets the right to auction this security and recover the proceeds. This is what is called as right of subrogation. When surety steps into the shoes of creditor. When does this happen? On payment of debt by surety. If surety pays the debt on behalf of the principal debtor fails and surety pays it, then automatically, as far as principal debtor and surety is concerned, between them, surety becomes creditor for principal debtor. That means he has the same right as the creditor has. Whatever the right original creditor had, same right will be now available for the principal, will now be available for the surety. This is what is called as subrogation. Same example is elaborated here. You can just read the example once. And once you complete reading the example, please give me a confirmation whether the things are clear to you. Please make sure you reply in the chat box that things are clear to you. Next, second right that surety enjoys against principal debtor is right of indemnity. Right of indemnity. Indemnification means making good of losses. Making good of losses. See, automatically, when surety pays the amount, surety becomes creditor for the principal debtor. This is agreed. Sometimes what happens is, in order to recover the debt, the creditor may sue principal debtor, or creditor may sue surety. Case might have been filed. A suit might have been filed. Now, when a suit is filed, obviously the party against whom the suit is filed may have to defend the case. Since he has to defend the case, he'll incur certain expenses for defending the case. Lawful expenses might have been incurred for defending the case. So where lawful expenses are incurred by the surety for defending the case, he has the right to recover such lawful expenses which he has incurred from the principal debtor. This is what is called as right of indemnity. This is what we consider as right of indemnity. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. The surety is entitled to recover from principal debtor whatever sum he has rightfully paid under the guarantee. Whatever sum he has rightfully paid. When you say rightfully paid, what does it mean? See, if it is valid to fight the case, if there are genuine reasons to fight the case and the surety fights the case, for that he incurs certain expenses. This is fine, rightfully incurred expense. Unnecessarily, when you go for a litigation, unnecessarily you incur any expenses, thus it will not be called as rightfully incurred expense. So only when the matter of indemnification comes, principal debtor will be liable to compensate the surety only rightful expenses, proper right correct expenses which are very necessary in that particular circumstance. This is what it says. X took a loan from Y which was guaranteed by Z. On default by X, Y filed a suit against Z. Z has to pay some legal expense besides loan of X. Now Z can claim those legal expenses from X. This is what is called as right of indemnity. These are the two rights available for surety against principal debtor. Two rights available for surety against principal debtor. Next party against whom I should exercise the right is right against the creditor. What are the rights available for surety against creditor? Surety, what and all rights can he enjoy against creditor? First one is right to get security. Security means collateral asset. Suppose if the principal debt is secured by a asset. Principal debt is secured by a asset, an asset. Once the surety pays the principal debt, whatever asset on which creditor had the right, now principal surety gets the right to recover it from the creditor. He can ask the creditor to give the particular security asset. Surety has the right to demand from the creditor all the securities which the creditor has against the debtor, whether they had been received before, at, or after the creation of guarantee, and whether those are in the knowledge of surety or not. See, law clearly states that whatever security creditor obtains, now creditor might have obtained it at the time of contract of guarantee. Creditor might have obtained it after the contract of guarantee or before the contract of guarantee. It may be known to surety, it may not be known to surety. Irrespective of that, once surety pays the debt, surety has the right over the security asset that is available with the creditor. Whatever security asset is available with the creditor, surety can demand for the same. Suppose jewel loan is taken. So you go to a bank, you take jewel loan on which your friend has given a guarantee. Now, jewel loan in the sense you will deposit the jewelry with the bank and you will take a loan on that particular jewelry for which your friend has given a guarantee. Now, what happens is, suppose if you fail to repay that particular loan and your friend pays it, now that jewels will go to your friend. Whether the friend knows it, whether the friend doesn't know it, whether the jewels were taken initially, whether the jewelry was taken later, irrespective of these particular facts, once the surety makes the payment, he gets the particular entitlement on the security. This is what section 141 clearly states. Pratham took an advance of 1 lakh from Chaman, which was guaranteed by Samar. Thereafter, Pratham gave jewelry of 1 lakh to Chaman as security, which was not in the knowledge of Samar. After some time, Pratham became insolvent. Chaman filed the suit against Samar. At that time, market value of the jewelry was 95,000. Here, Samar is liable for 5,000 only because this particular thing, whatever is there, Samar also has a right in this particular thing. So this is about right to get security, section 141. Moving on further. Second right is right to claim set off. Right to claim set off. Let us say contract number 1. Contract number 1. Disha gives a loan to Sneha, say of 1 lakh. Contract number 1, Disha gives a loan of 1 lakh to Sneha, for which, say, Deepak gives a guarantee. For which Deepak gives a guarantee. For this loan, Deepak is the surety. Contract number 2, Sneha supplies goods on credit worth rupees 20,000 to Disha. Sneha gives goods. Sneha supplies goods worth rupees 20,000 to Disha. Now, tomorrow when the settlement happens, settlement will be 1 lakh minus 20,000. Whatever mutual owings is there, that mutual owings will be cancelled. And Disha can hold Sneha liable only to the extent of 80,000 rupees. Now, when Disha can hold Sneha only liable to the extent of 80,000 rupees, same thing will apply to Deepak also. Deepak can also take the benefit of this set off. Since Deepak is paying the debt on behalf of Sneha, if Sneha can get this set off, even Deepak can get this set off. So tomorrow, only 80,000 rupees can be recovered from Deepak. Only 80,000 rupees can be recovered from Deepak. This is called as set off. Surety may have the benefit of set off, if any, that the principal debtor had against the creditor. So if principal debtor has the right of set off, the same should also be given to surety. This is what the principle says. Right of set off, right to set off. Next, right to share reduction. Let us try to take this with the help of example given there so that things will be easier for us. X took a loan of 5,000 from Y, which was guaranteed by Z. X became insolvent and only 25% is realized from his property. So out of 5,000, only 25% is realized. 5,000, 25%. Now what is it? It is 1,250. Only 1,250 could be recovered. Now Y will receive 1,250 from X. So reduction, whatever is there, reduction means this much is already recovered. No? Out of 5,000, 1,250 is already recovered out of the estates. So surety will be liable only to the extent of 3,750. That is what is called as reduction. This is the reduction. It normally happens when the principal debtor becomes insolvent and only dividends out of his property can be recovered. Surety has the right to claim proportionate reduction in his liability if principal debtor becomes insolvent. If principal debtor becomes insolvent. These are the three rights available for surety against creditor. Three rights available for surety against creditor. Moving on further, rights against co-sureties. Co-surety means person who has joined as surety to the main person. So loan 1 is there, which is worth say 9 lakh, for which there are three co-sureties, surety 1, surety 2, surety 3. Each one of them are called co-sureties. Each one of them are called as co-sureties. Now, what will be the liability of co-sureties? That is what we are seeing here. Right to claim contribution equally. Contribution. So, unless otherwise agreed, each surety is liable to contribute equally for the discharge of whole debt or part of the debt remains unpaid by the debtor. Each co-surety shall be liable equally. They are liable to contribute equally. So, for a loan of 9 lakh rupees, each of the co-sureties will be liable to the extent of 3 lakh. Equal contribution needs to be given. This is what law assumes, unless otherwise agreed. Unless otherwise agreed is the word which law uses. That means if there is a contract between the co-sureties for a different ratio, this is all about ratio. So if there is a different ratio agreed between the co-sureties, then such ratio will be applicable. Where no such ratio is defined, we will contribute equally. Co-sureties are required to contribute equally. Equally means 1:1:1. If three co-sureties are there, 1:1:1. That means equal contribution. Each one of them will be contributing equally. However, if co-sureties have guaranteed for a different sum, they are liable to pay equally as far as the limits of their respective obligations permit. If co-sureties have guaranteed for a different sum. Now, let us try to put this with the help of an example and try to elaborate this. Say a particular debt. There is a particular debt of loan rupees 5 lakh. Three co-sureties are there. Surety 1, surety 2, surety 3. Surety 1 says his liability will be limited only to the extent of 1 lakh. Surety 2 says his liability will be limited only to the extent of 1,50,000. So they have limited their amount. Now how to appropriate this 5 lakh rupees among them? To the extent of 1 lakh, since all are going to contribute equally, I'll appropriate somewhat like this. This will be appropriated like this. So surety 1, surety 2, surety 3. 1 lakh, 1 lakh, 1 lakh. Because for 1 lakh, there is no limit. Now what remains is 3 lakh is done. For 3 lakh, all are equally liable. Now balance 2 lakh. How to appropriate? Balance 2 lakh. In balance 2 lakh, you see here, surety 1 is not going to contribute anything because he has limited his liability to 1 lakh. Surety 2, I cannot give him entire 1 lakh, 1 lakh because his liability is limited only to the extent of 50,000. So what I'll do is first 50,000 rupees I'll appropriate between them. 50,000, 50,000. So again, 1 more lakh is appropriate. 3 lakh plus 1 lakh, 4 lakh. Balance 1 lakh will be given to surety 3, will be borne by surety 3 because there is no limit on surety 3. So likewise, what happens is 1 lakh plus 1.5 lakh plus 2.5 lakh within their limits. This is what is said here. If co-sureties have guaranteed for different sums, they are liable to pay equally as far as the limit of their respective obligations permit. Till their limit, they are liable to pay equally. After their limit, they will not be held liable. Other co-sureties will be held liable. This is what is the procedure for appropriation of payment. When co-sureties have fixed the amount of their guarantee. What is the maximum amount of their guarantee if they are fixed? This is the way in which the liability will be fixed. So with this, we conclude the discussions on contract of guarantee also. Contract of guarantee discussion also comes to end. Please give me a confirmation whether the things that we have discussed till now is clear for us. That's very nice. Since we have completed the discussion on this particular chapter, we will go through some questions, practical questions, and get some idea on how to solve them. I'm not going to solve detailedly, but basic overview on contract of guarantee, contract of indemnity, and contract of guarantee. Let us solve some questions for our understanding or to check our understanding on the topic. So contract of indemnity, we have a question here. First question, contract of indemnity. S asks R to beat T and promises to indemnify R against the consequences. R beats T and is fined 50,000 rupees. Can R claim 50,000 from S? What is your answer? Contract of indemnity must fulfill all essential elements of valid contracts. Promise to indemnify an unlawful act is void. Hence, R cannot claim 50,000 rupees from, yes, R cannot claim because it is unlawful act. Someone had given the right answer, probably that I deleted it. So the right answer is cannot be claimed because it is not meeting the essential element. Contract of indemnity for will be for lawful acts only. For unlawful acts, there cannot be a contract of indemnity. There cannot be a contract of indemnity for unlawful act. Yes. Yeah. Then why did you delete, my dear? You were right, no? Okay. So moving on further. Second one. The first question in contract of guarantee. We'll see some questions here. Surendra guaranteed Virendra for transactions to be done between Virendra and Jitendra. So Surendra is giving a guarantee. Virendra and Jitendra are there. Surendra is giving for transaction done between Virendra and Jitendra. Virendra is supplying the goods to Jitendra. Surendra is giving the guarantee to Virendra. Virendra supplied goods of 30,000 rupees on 1/3/2021 and of 20,000 rupees on 3/3/2021 to Jitendra. On 5/3/2021, Surendra died in a road accident. On 5/3/2021, Surendra died in a road accident. On default, sorry, on 10/3/2021, being ignorant of death of Surendra, Virendra further supplied goods of 40,000. On default in payment by Jitendra on due date, Virendra sued on legal hires of Surendra for recovery of 90,000 rupees. 90,000 because 30 plus 20 plus 40. 90,000. Describe whether legal hires of Surendra are liable to pay 90,000 under the provisions of Indian Contract Act. What would be your answer if the estate of Surendra is worth 45,000 only? That is second part of the question. That we can consider later. Whether legal hires of Surendra are liable to pay 90,000. So we have discussed in yesterday's class itself that in case of continuing guarantee, when the surety dies, the continuing guarantee stands revoked as to future transactions. That means the surety will be liable, surety's estates will be liable only to the extent of transactions done till the date of death. Whether the matter of death is known to creditor or unknown to creditor, irrespective of that, the surety can be held liable or surety's estate can be held liable only to the extent of acts done till the date of death. That is why here death occurs on 5/3/2021. Before the date of death, there are two transactions. 30 plus 20, 50,000. To the extent of 50,000 rupees, Surendra's estates are liable. However, for the debt incurred after the date of death, that is 40,000 rupees, Surendra's estates are not liable. So nothing can be recovered from legal heirs as against that transaction. What would be your answer if the estate of Surendra is worth 45,000 only? If the estate of Surendra is worth 45,000 rupees only, legal heirs shall be liable only to the extent of 45,000 and not to the extent of 50,000. Reason being, in case of succession, the legal heirs of a person shall be liable only to the extent of assets succeeded or assets inherited from the deceased person. estates inherited from the deceased person. So only up to the extent of 45,000 rupees, they will be liable. Only to the extent of 45,000 rupees, they will be liable if the assets are worth 45,000 only. This will be your answer. Let us see two more questions. Second one we'll see. Mr. Sanjeev, dealing in high quality timber. Mr. Amit wants to purchase the timber from him on credit, which is to be used in renovation of his house. Mr. Pramod gives guarantee to Mr. Sanjeev for timber to be supplied to Mr. Sanjeev, supplied by Mr. Sanjeev to Amit. Pramod is giving guarantee on behalf of Amit to Mr. Sanjeev. Mr. Sanjeev supplied the required timber to Mr. Amit. Afterwards, Mr. Amit embarrassed and contracts with the creditor, including Mr. Sanjeev, to assign to them his property in consideration of their releasing him from their demands. On due date, Mr. Sanjeev filed a suit against Mr. Pramod for recovery of the payment of timber due to Mr. Amit. Explain with reference to Indian Contract Act whether Mr. Sanjeev can claim the payment from Mr. Pramod. Now, yesterday again, discharge of surety by conduct of the creditor. Under that heading, we have discussed that if the creditor and principal debtor enter into an agreement with themselves without the consent of surety, which has the effect of releasing the principal debtor, such a case, surety shall also stand discharged. So going by that provision, we can answer that since here the contract is entered between Amit and Sanjeev without the consent of Pramod, which has the effect of releasing Amit from the contract, Pramod cannot be held liable as his consent was not obtained before altering these terms and conditions. So this can be the possible answer in case of question number 2. In case of question number 2. Next, question number 3. Salil purchased furniture worth 1 lakh from Mr. Puran on credit. Mr. Raman entered into contract with Puran for the guarantee of payment by Mr. Salil. On due date, Salil could not make the payment due to his financial crisis. Mr. Puran filed a suit against Mr. Raman for payment. Meanwhile, father of Mr. Salil paid 20,000 rupees to Mr. Puran on behalf of his son. Mr. Raman, in ignorance of the above payment, paid 1 lakh to Mr. Puran as a surety. Afterwards, when Mr. Raman knew the facts, he asked Mr. Puran for refund of 20,000 rupees. Mr. Puran denied for refund with the words, that's only Mr. Salil who can claim the amount of 20,000 rupees. Explain with reference to Indian Contract Act whether Mr. Raman can claim the refund of 20,000 rupees from Mr. Puran. Now, going by the provisions of contract of guarantee, this is a simple question based on liability of surety. And we have understood that liability of the surety is coextensive with that of liability of the principal debtor. So only to the extent of what principal debtor is liable, to that extent surety will be liable. So in this case, when father of Mr. Salil pays 20,000 rupees on his behalf and Puran accepts it, Puran cannot claim that 20,000 rupees from Salil. He can only claim 80,000 rupees from Salil. Since he can recover only 80,000 rupees from Salil, even Mr. Raman, the guarantee shall also be liable only to the extent of 80,000 rupees. So when he pays 1 lakh rupees, he has all the right to claim back 20,000 rupees from Mr. Puran. He has all the right to claim back 20,000 rupees from Mr. Puran. Since the liability of principal debtor is 80,000, even surety's liability will be restricted to 80,000 rupees only. 80,000 rupees only. This is what is the point to be observed. So like these similar questions, you can see so many questions are there. These questions are there in CA intermediate revision test paper, old revision test paper of CA intermediate. So there you can compile these questions. Institute has already been asking questions in CA intermediate examinations. Of course, now it is removed in CA intermediate. So definitely similar questions can be expected in CA foundation exams. So that questions will be sufficient because majority of the questions are similar in line. So you can take into consideration all these things. Few questions are already available on your materials also, study material also. Same things can be referred. So with this, I conclude the discussion on contract of guarantee. Please make sure you understood the concept of contract of guarantee and give me a confirmation so that I can proceed ahead for the next topic to come up, that is contract of bailment. For the next topic to come up, that is contract of bailment. Hello, Abhay. Nice to see you here. Congratulations on clearing your CA foundation. All the best for your CA intermediate. Yes, sir. So, getting back to our discussion, the next topic that we are going to take up is contract of bailment. And then comes something similar to bailment, what we call as pledge. So, Unit 8 of your Contract Act deals with this topic, contract of bailment and contract of pledge. Bailment. Probably in the Sale of Goods Act chapter, we have come across this concept called as bailment. We differentiated between bailment and sale. So what exactly is bailment? Probably to analyze this, we will divide the discussion. We will derive the discussion from Sale of Goods Act only. Let us say what is contract of sale. Section 4 of Sale of Goods Act defines what do you mean by contract of sale. Going by that, what does it say is something like this. There will be two persons. One is called as seller and there is one more person called as buyer. It is a contract between seller and buyer where seller transfers property in goods to buyer. Seller is transferring the property in goods to buyer for price. This is the main thing that happens when it comes to contract of sale of goods. So there will be transfer of property in goods to buyer for price. Now, when we analyzed the provisions of Sale of Goods Act, we saw the definition of property and we understood that property means general property. That means ownership. Here, property meant ownership in the goods, or what we call as general property in the goods. General property in the goods. General property means you should transfer the ownership. Your goods, you are giving it to other person and the ownership is transferred to the other person for some price. I consider it as sale. That is what is called as selling of goods. On the other hand, if you are not transferring the ownership, rather you're only transferring the possession to the other party. Physical possession of the goods is transferred to other party. You have no intention of making him the owner. It is for some purpose you are delivering it. Then I'll consider it as contract of bailment. So again, there are two parties. This is contract of sale we are discussing. Here, when I discuss about bailment, same thing. There are two parties here also. One party is transferring the goods. One party is transferring the property in the goods for some purpose. Where the property in the goods is transferred to other persons for some purpose. Now, the principal difference between sale and bailment is this word property. When it comes to sale, we say general property, that is the ownership of the goods. When it comes to bailment, we are saying it about only special property. That is possession. Only the possession in the goods is getting transferred. You're not making the other party owner of the goods. Rather, you're only giving him the possession for some purpose. So, classic example. You are in between a class. Classroom discussion is happening. Your ink in your pen exhausts. Your ink gets over. Your pen's ink gets over. Suddenly you ask your friend, do you have an extra pen? And you ask your friend to give that extra pen. You ask your friend to give that extra pen that he has. When the friend gives you the pen, you literally don't become the owner of that pen. There is no transfer of ownership. Once you complete the purpose, it is given for one purpose. For that particular hour, you need to write the notes. For that purpose, the pen is given to you. Once the purpose is over, once the purpose is accomplished, you are required to return the pen to the owner. Of course, you don't do. That is a different story. But the basic rule under contract of bailment is that that exact thing is there. No right to claim back the goods. That is why we consider it as contract. The person who has delivered the goods has the right to claim back the goods. That right to claim back the goods is coming only because of contract of bailment. So where one party gives his goods to other person so that the other person can use it or for some purpose. See, when I say some purpose, purpose can be either for the benefit of the bailer, the person who is giving the goods, or for the benefit of the person to whom the goods are given. When you give clothes to a tailor, you want to get it stitched. Now there is a mutual benefit. You will get the clothes, he will get the money. Suppose your friend wants to keep his jewels at your place so that he can go on a tour and come back. Your friend has a benefit there. His jewels are safe in your hands. That is why he is giving. So the party who is giving has the benefit there. Suppose your friend needs a car for his purpose. You give the car to him. For his benefit, you are giving the car. So all these cases are considered as bailment. In case of bailment, what happens is, first thing is the goods will change the hands. There is a change in the possession of the goods from one person to another person. Second thing is, there will be some purpose for that particular transfer of possession. Once the purpose is accomplished, either the goods should be returned to the true owner, whosoever the owner is there, to him the goods should be returned, or it should be disposed of according to his direction. Whatever direction he gives, according to that direction, it should be disposed of. Say, for example, you want a parcel to be delivered to your home. You are in one particular location. From that location, you want to transfer the parcel. You want to give the parcel to your home. You give it to a courier agency. When you transfer the possession of the goods to the courier agency, it is given for some purpose. Purpose is to get it delivered to your place. Now, once the contract is over, once the purpose is after it is taken to your place, it will be delivered according to your direction. This is also considered as bailment. Even this can be considered as bailment. Bailment is, again, transfer of possession of goods from one person to another person for some purpose, on completion of which, or on accomplishment of which, the goods shall be returned to the true owner or disposed of according to his directions. According to his directions. This is what is called as contract of bailment. This is what we consider as contract of bailment. So, meaning is given under section 148 of Contract Act. Meaning of contract of bailment is given under section 148. What does it say? Delivery of goods. Here delivery means physical transfer of possession. Delivery of goods by one person to another. One person is delivering the goods to another person for some purpose. For some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed according to the directions of the persons delivering them. So delivery, physically transferring the possession of the goods from one person to another person for some purpose upon a contract that they shall, when the purpose is accomplished, once you complete the purpose, be returned or otherwise disposed of according to the directions of the person delivering them. Whosoever person is, according to his directions, the goods will be disposed of. So we can give n number of examples. Giving a car to a friend, borrowing a book from a library, giving clothes to a tailor, giving car for a repair. In all these cases, once you give the goods to the other person, he is not going to become the owner of the goods. He is not going to become the owner of the goods. Rather, the purpose, there will be some purpose. Either the other person is taking it for his personal usage, or for your benefit, or for mutual benefit of both of you. Once that purpose is accomplished, the goods will be either returned back to the true owner or it will be disposed of. Disposed of means it will be done as per the true owner requires. Whatever the true owner says, according to his directions, the goods will be given or goods will be disposed. This is what is called as contract of bailment. This is what is called as contract of bailment. Delivery of goods for a purpose upon a contract. The contract is that once the purpose is accomplished, the goods must come back to the true owner or it should be disposed of. Delivery of goods for a purpose upon a contract that when purpose is accomplished, it will be returned or otherwise disposed of. Examples of bailment: giving clothes to a tailor to be stitched, giving bike on a rent. We have this bounce, or we have this Zoom car, these concepts where you take the car from that particular Zoom and you use it and you give it back, hiring the car. So giving bike or car or rent. Giving book to a friend to read, giving watch for repair. Or sometimes you do this, no, you have a cell phone, you give it to other person to take a snap of yours. This will not make the other person owner of that particular goods. Rather, it is given for a purpose. On accomplishment of purpose, it will be returned back to you or it will be disposed of according to your direction. Whatever you say, according to your direction, it will be disposed of. So this is what is called as contract of bailment. These are the examples. Essential elements of contract of bailment. What are the essential points to be kept in mind with respect to contract of bailment? First and foremost thing is there must be an agreement between bailer and bailee. See, agreement can be express, agreement can be implied. Express means you expressly agree. This is the terms of the contract for up to for these many days. I am giving my particular goods to you. After the usage, you have to return it back to me. This is express contract of bailment. Sometimes implied. Implied means what? Say someone finds a goods. Finder of lost goods, we say. Finder of lost goods. Someone finds goods that belongs to some other person. Now, what it does, what the duty of such person is to return, give back the goods to the true owner, even though there is no contract. Law assumes we consider it as quasi contract. Correct? So even that can be considered as bailment only. Implied contract of bailment. That can be an example of implied contract of bailment. Delivery. Transfer of possession of goods by bailer to bailee. This is also important. Now, delivery, types of delivery are already seen in Sale of Goods Act. We normally come across the types of delivery in Sale of Goods Act. So, according to Sale of Goods Act, we have actual delivery. Goods are physically over to the other person. Constructive delivery normally happens due to acknowledgement when the goods are in the possession of third party. I'll call it as constructive delivery. Symbolic delivery is doing something to symbolize the delivery. However, all these things are not very relevant here for this particular discussion. You just keep in mind there should be delivery of goods. That's it. Delivery means transferring the possession. Special property is getting transferred. Possession is getting transferred. Transfer of possession of goods by bailer to bailee. This is what is getting discussed. Next, essential elements for bailment. Third one is delivery of goods for some purpose. If goods are delivered by mistake, there is no bailment. The goods should be delivered for some purpose. There should be some purpose for delivering the goods. Purpose can be either for the benefit of the bailer. The person who is delivering the goods is called as bailer. The person to whom the goods are delivered are called as bailee. So two parties you should remember, bailer and bailee. Person delivering the goods is called as bailer. Person to whom goods are delivered are called as bailee. Person to whom the goods are delivered are called as bailee. X gives his books to Y to be delivered to Z, but mistakenly Y gives it to M. X giving the books to Y is bailment, but Y giving it to M is not bailment because the goods are not to be delivered to M, but it should be delivered to Z. Then next important feature is returning of goods. Return of goods or disposed of according to the directions of the bailer after the purpose is accomplished or period of bailment is expired. Once the particular purpose is over, once the particular, say for example, you have dropped your car for repairing, getting it repaired. Now, once the repair work is done, the requirement is that the mechanic should return the car to you according to your direction. So, returning of goods, disposing it off, courier agency, I said. You have given the goods to the courier agency. Now, courier agency has to deliver it to the other party. So, now here the goods are not coming back to you. Rather, it will be given to someone else. Rather, it will be given to someone else according to the directions. According to the directions of the person delivering it. According to the directions of the person delivering it. So, this is what is called as returning of goods or disposing of the goods. Returning of goods or disposing of the goods. Another important character. Next, change of possession. Possession should change. That means the goods should change its position from one person to another person. So, say for example, servant of a master who is in custody of goods of the master does not become bailey. Say you have an agent and that agent holds the goods on your behalf. Now, that is not to be considered as bailment because the people are not different, one and the same. Agent is the same person as the principal. That is why. So, in bailment, possession of the goods should change. Bailer continues to be the owner of the goods. When a person is in the custody without possession, he does not become bailey. Now, best example we can give is you deposit your ornaments in the bank locker. See, when you deposit the ornaments in the bank locker, what happens is you will retain a key with yourself. If you give this key to the other person, there is a symbolic delivery, and I'll say that that particular goods are delivered. But when you retain the key to yourself, when you retain the key to yourself, that will not make any delivery. It is not to be considered as delivery. So when there is no change of possession, even though the goods are kept there is no transfer of possession happening. You go to a parking lot and you park your car and come back. See, the keys are with you. Car physically cannot be given. There should be something that symbolizes the delivery. You have not symbolically done anything to give the delivery. There is no change of possession. It's just that you parked the car somewhere. It will not be considered as bailment. You depositing the jewels in the bank locker will not be considered as bailment. All these are not to be considered as bailment because there is no transfer of possession happening here. Even though it looks like you have changed the possession, there is no possession changes because depositing the jewels in the bank locker is just an exercise that you do where the keys are with you only. That means there is no question of delivery happening there. If you give the keys to someone else, probably then I'll consider it as delivery. But retaining the key with yourself will not be considered as delivery at all. That is why there is no change of possession. So when there is no change of possession, it will not be considered as delivery of goods. Where there is no delivery of goods, there is no bailment. So for bailment, what is important is change of possession from one person to another person. For some purpose, everything is important. So mistakenly you do something that is not bailment. You don't even transfer the possession, that is not bailment. All these things are to be kept in mind as characteristics. Some more examples. Examine whether the following constitutes a contract of bailment. V parks his car at a parking lot, locks it and keeps the key with himself. Answer, you see, mere custody of goods does not mean possession. There must be transfer of possession from bailer to bailee. Possession should transfer from one hand to another hand. Only then it will be considered as valid contract of bailment. That is why, in this case, there is no contract of bailment. There is no contract of bailment. So you should keep in mind this particular part. Similarly, seizure of goods, custom authorities, that is your tax authorities seizing your goods, will it amount to bailment? Should it be considered as bailment? So you see there, mere the possession of the goods is transferred to the custom authorities, therefore bailment exists and section 148 is applicable. Even though you are voluntarily not transferring the possession there, the goods are transferred to other person for some purpose. Once that particular purpose is completed, that is, they want to recover the tax from you. Once you pay the tax, the goods will come back to you. So in this case, you should keep in mind that it will constitute a bailment. It will be considered as bailment. Next, having bank locker. Just because you have a bank locker and you deposit your ornaments in the bank locker, it will not be considered as bailment. It will not be considered as bailment because there is no transfer of possession happening. It is mere custody that is getting transferred and not the possession. So please go through the facts that we have discussed. Then we can get into the further discussions. I'll give you 2 minutes. Please glance through the slide. Then we can continue our discussion. So what is meant by seizure of goods? Seizure of goods means custom authorities taking the goods into their custody. Seizing. You are using mobile phones in your class. So the faculty in the class comes to you and he takes your mobile phone to his custody. That is called a seizure. That is called a seizing. Seizing. This is normally done when you transport the goods from one place to another place without paying the proper taxes, or when you import the goods and you don't pay the tax. In all those cases they do. I hope it is clear. Now, classification of bailment. The division happens based on two categories. One is based on the benefit, one is based on the consideration. For the benefit, some benefits are on, some bailments will happen only for the benefit of the bailer. Bailer means the person, for his benefit we normally deliver the goods. For the exclusive benefit of the bailer, see here, delivery of valuables to a neighbor for safe custody. You are giving your ornaments to your friend so that he can keep it safely, and once you come back, maybe you are going for a tour, once you come back he'll return the goods to you. This is safe custody for your benefit. You are not, your friend is not going to charge you anything here. This is called as for the exclusive benefit of the bailer. Say suppose you have a puppy and you want to go on a tour. maybe you are going abroad for 1 week, sorry, for 15 days, foreign trip you are going. So you definitely cannot keep the dog yourself. You cannot retain the dog with you. So there should be someone to look after the dog. So what you do is you give this puppy to your friend and ask them to look after this puppy. Now what you are doing is you are bailing out your goods. It is not for the benefit of your friend. It is for the exclusive benefit of you, the owner of the goods. This is called as exclusive benefit of the bailer. Sometimes exclusive benefit of the bailee, say maybe Vaishak needs a car. Say Anil has a car. Now Vaishak calls Anil, can you lend me your car for a week? I'm going on a tour, so please give me a car for a week. So if Anil gives his car to his friend Vaishak, now what happens is, even though no consideration is received, here the goods are given to Vaishak for his benefit, that is bailee's benefit. Even this will be considered as bailment. Here the bailment is for the exclusive benefit of the bailee. Exclusive benefit of the bailee. Then for mutual benefit of the both. Mutual benefit means both will be benefited. If you give clothes to ironing, you will get your clothes ironed, the person will get the money paid. If you are giving your car for repair, you will get your car repaired, other person will be paid for his service. So this is what is called as mutual benefit. For both the parties, there is a benefit. Renting out a car, hiring out a car, you are giving your car to other person. He'll enjoy the car, you will also get the rent. So this is mutual benefit of both the parties. Now, based on the consideration, see, consideration is not mandatory in case of contract of bailment. We already seen this under discussion under section 25. Under section 25, we said exception to section 25. That means contract, those are valid even without consideration. Contracts which are valid even without consideration, in which we discussed contract of bailment as an example. We said in case of contract of bailment, even if there is no consideration, the contract will be valid. Even if there is no consideration, the contract will be valid. So consideration is not an important element, but in some cases, consideration will be received. In some cases, there will not be any consideration. So where for the purpose of bailment, you are getting the consideration. You bail out your goods and you are getting consideration for that. Zoom car example I give. The car is given to a customer. Customer will pay the rent for that. It is called as non-gratuitous bailment. It is called as non-gratuitous bailment. When the goods are bailed for some consideration, it is called as non-gratuitous bailment. On the other hand, they are not going to receive any consideration. You giving your car to your friend, you giving your possession goods to your friend for safe custody. In both the cases, no consideration is received by both the parties. I will consider it as gratuitous bailment. It is called as gratuitous bailment. So non-gratuitous bailment and gratuitous bailment. Again, two types of bailments based on consideration. Based on benefit, we have three types. Bailment for the benefit, mutual exclusive benefit of the bailer, bailment for the exclusive benefit of the bailee, bailment for the benefit of both the parties. With respect to consideration, we have two types of bailment, gratuitous bailment and non-gratuitous bailment. Gratuitous bailment and non-gratuitous bailment. Is it clear? Please make sure that you are understanding the topics clearly. Please give me a confirmation here. Is it clear? So classification based on consideration also is elaborated in the board. Please see the example given on the board. Next, what we need to consider is duties and rights of bailer and bailee. What are the duties? What are the rights of bailer and bailee? Bailer means the person who is giving the goods on bailment. Bailee means the person to whom the goods are given on bailment. So duties and rights of bailer and bailee is what we are discussing now. So one by one, let us discuss. Duties of bailer. To disclose known facts, known faults in the goods. So now we discuss this under two headings. One in case of gratuitous payment, another one in case of non-gratuitous payment. Gratuitous bailment means bailer is not going to receive any consideration. Bailer or bailee, either parties are not going to receive any consideration. It will be for the exclusive benefit of one party. No consideration is involved. Such a bailment is called as gratuitous bailment. Now, in case of gratuitous bailment, say for example, you have a car, you are giving your car to your friend for his usage. For your friend to use the car, you are giving the car to your friend. Now, what is your duty is, if there is any fault in your car, which are very important to be known by the other person before using that particular goods, it becomes your duty to give him the knowledge about such fault. So you know that your car's brakes are not working perfectly fine. Now it becomes your duty to inform your friend that the brakes are not working fine. Suppose you don't disclose this, despite of knowing it, if you don't disclose it, then whatever loss your friend may suffer, you will be liable to compensate the same. You will be liable to compensate the same. So that is what is said in point A here. Bailer has to disclose all the faults known to him which are material for use of goods, or which may put bailee to an extraordinary risk. Effect of not disclosure. If you do not disclose, what will happen? Bailer shall be liable for damages for any loss caused to bailee. Bailer shall be liable for damages for any loss caused to bailee. A gives his bike to his friend B. A knows that the brakes of the bike are not working properly, but he does not inform to B. B meets an accident. A is liable to pay the damages. Now, suppose if A can prove that, sir, even I did not know. If A can prove this in the court, then A will not be held liable. So, if bailer himself is not aware about that particular fact, then bailer need not. There is no obligation on the bailer to disclose the default in the goods. So, if bailer knows it, bailer has to disclose it. If bailer does not know it, bailer need not disclose it. This is with respect to gratuitous bailment. On the other hand, if you are taking a Zoom car, it becomes the duty of Zoom car to ensure that goods are in fit condition. There should not be any default at all. There should not be any default at all. So it should be free from default. So technically speaking, the line says like this: bailer has to disclose all facts, whether known to him or not known to him. Now, if it is not known, then how can he disclose? Not possible. No. So practically speaking, it means that it becomes the duty of the bailer to see that the goods are in fit condition. There is no default existing in such goods. That is the duty of the bailer. So even though we say it like this, bailer has to disclose all the facts, whether known to him or not known to him. If it is not known to him, how can he disclose? Practically, that is not possible. No. So what law says is it becomes the duty of the bailer to give the goods in the fit condition, bailor shall be liable for the damages for any loss caused to bailee, whether or not bailor was aware of the default. So you have taken a Zoom car, you take it for a ride, you take it for a drive, and there, because of some defect in the car stops working and you suffer some loss. It becomes the duty of the bailor to compensate you for the loss. A gives his bike to B on hire, rent. The brakes of the bike are not working properly. B meets an accident. A is liable to pay damages, whether the fault on the bike is known to him or not known to him, irrespective of that. Irrespective of the fact whether the fault is known or not known, he will be liable to compensate. This is with respect to disclosing faults in the goods, known faults in the goods. Next, indemnity, indemnifying bailor, indemnifying bailee, where bailor does not have title for the goods. Bailor is not the owner of the goods. Without having proper title, bailor bails out the goods. X gives his neighbor's car to Y for use without neighbor's permission. Neighbor sues Y and gets compensation. Now, X is bound to indemnify Y for the loss because X was not the owner of the goods. Still, without taking the permission of his neighbor, he bailed out the goods, because of which Y suffered the loss. Now, X has to compensate Y. Now, you have given your car to your friend. Let us say, for example, Anil has given his car to Vaishak. Vaishak had asked for the car. Anil has given the car for 1 week. Say Vaishak fills in the petrol, full tank petrol he does, 35 liters, let us say 35 liters of petrols are filled in. After which Anil calls Vaishak and says, Macha, I want the car back. I can't give you the car. Sorry, I want the car back. Now, in this case, what Anil is doing is called as premature termination. He is putting an end to the contract of bailment even before the due date. See, this is only possible in case of gratuitous bailment. In case of non-gratuitous bailment, say Zoom car has given you the car. You have taken a car from Zoom. You are planning for a trip and you have taken it to travel till Goa and come back. When you are midway, Zoom car cannot call you and say that give back the car. It will amount to breach of contract and consequences of breach of contract will be attracted. Now, only in case of gratuitous bailment, there can be premature termination because he is the owner of the goods. So definitely he can call back the goods anytime. But only is that petrol expenses what Vaishak has incurred, no, without taking any benefit out of that particular petrol, he has incurred an expense of 3,500. So if the expense incurred is more than the benefit derived, then such expenses must be compensated by Anil. Anil has to compensate him those expenses. So X lends his old car to Y gratuitously for 4 months. Y incurs rupees 1,000 for repairs. If after 1 month X asked to return the old car, he has to compensate Y for the expenses incurred in excess of the benefit derived. Maybe old car, no, he might have done some repair works. After getting it repaired, he might not even properly used it. So now it becomes the duty of the bailor to pay the expenses incurred. Whatever the expenses incurred by bailee, that expenses must be compensated. This is with respect to indemnifying the bailee. Indemnifying the bailee. Now, duty to bear the expenses. Duty to bear the expenses. See, there are two types of expenses. One is necessary expense, one is extraordinary expense. If you're taking a car, for example, if someone is giving you a car and you want to use it, this petrol or maybe filling in air or some small minor repairs what you do, these are considered as necessary expenses. To use the goods, these expenses are very necessary. Suppose if there is a defect in the engine, which you are getting repaired, there's a big defect in the engine which you are getting repaired. That is called as extraordinary expense. That is called as extraordinary expense. So now, if the bailment is non-gratuitous, then the bailer shall bear only the extraordinary expenses and not the ordinary expenses. Necessary expenses need not be borne by bailer. It is only the extraordinary expenses that bailer has to bear. So you take a car on hire, you will be liable to pay the petrol charges and other minor expenses. If you incur a bigger expense, extraordinary expense for that, repair of engine or something like that, that expense you can ask the bailer to compensate. On the other hand, if it is gratuitous bailment, now we have to see, when it comes to gratuitous bailment, we have to see one thing, whether the gratuitous bailment is for the benefit of the bailer or whether it is for the benefit of the bailee. Say, for example, you have given your dog to your neighbor to look after it. You are going somewhere else, so you have given your dog to the neighbor to look after it. Now, the dog's daily food, whatever is there, becomes a necessary expense. Since it is for your benefit, the neighbor has taken over the dog, you shall bear the necessary expense. You have to compensate him the necessary expense. Suppose one fine day the dog falls sick and the neighbor takes it to the hospital and gets it treated. Now the extraordinary expense also needs to be borne by bailer only. This is only when the goods are bailed for the benefit of the bailer. So this is not 100% correct. Whatever is given here, both necessary and extraordinary expenses are to be borne by bailer if it is for the benefit of bailer. If it is for the benefit of bailer. A gives his bike to his friend B gratuitously. It runs out of petrol. B can recover petrol charges from A. Let's say if bike suffers a breakdown and B has to repair the charges. B has to repair and incurs repair charges. These charges can also be recovered from A. If in the above example, A gives his bike to a friend B on hire, B can recover only repair charges and not petrol charges. This is what is the duty of bailer. Next, duty of the bailer to return, take back the goods. It is the duty of the bailer to take back the goods. If bailer refuses to take the goods back, bailee can claim compensation for necessary and incidental expenses which the bailee undertakes to keep and protect the goods. So bailer has to take back the goods within the due time. Now, within the due time, if the bailer refuses to take back the goods, the time is over, the particular purpose is accomplished, then also bailer is not taking back the goods. Now, whatever expenses bailee is to incur, for safeguarding that goods, even after the lapse of time, if the goods are lying with the bailee only, whatever extra expenses bailee is going to incur for safeguarding, protecting the goods, bailer has to compensate bailee for such expenses. Bailer has to compensate bailee for such expenses. So if bailer refuses to take the goods back, bailee can claim compensation for all necessary and incidental expenses which the bailee undertakes to keep and protect the goods. X delivered his car to Y for 5 days for safekeeping. However, X did not take back the car for 1 month. In this case, Y can claim the necessary expenses incurred by him for the custody of the because you are not taking back, he will have to incur some expenses for safeguarding it. That expenses can be recovered. So X delivered his car to Y for 5 days for safekeeping. However, X did not take back the car for 1 month. In this case, Y can claim the necessary expenses incurred by him for safe custody of the. Whether this is clear? Duties of bailer, all the duties that we have discussed till now, whether it is clear. Okay. The next thing we need to discuss is rights of bailer and then duties of bailee and rights of bailee, which I'll take up after a brief break of 10 minutes. I'll be coming back here only. So session will not be changed. We'll be live here only. The same session will continue, but we'll have a small break of 10 minutes so that we can get refresh and come back. And then we can continue our discussion from the next part, that is rights of. Yes. I'll be joining back in 10 minutes. Let's restart. Ask your friends to join back. Those students who had left the live session, please ask them to join back. Let us restart our discussion. So we were discussing about the rights and duties of bailer, rights and duties of bailee. So to quickly summarize, let us go back to the summary sheet. First, we discussed about duties of bailer. First, we discussed about duties of bailer. So speaking about duties of bailer, what did we say is it is the duty of the bailer to show the to disclose the known facts, known faults to him. In case of gratuitous bailment, if the fault is known and still the bailer does not disclose it, then he will be liable for damages. However, if the faults are not known to him, he will not be liable for the damages. However, in case of non-gratuitous bailment, it becomes the duty of the bailer to deliver the goods in fit condition. That means whether he knows about the faults or whether he is not aware about the faults, in either cases, he will be held liable for the faults in the goods. Next is indemnify bailee. Again, the discussion was divided into two categories: gratuitous bailment, non-gratuitous bailment. In case of non-gratuitous bailment, bailer will be responsible for indemnifying extraordinary expenses. Extraordinary expenses. Engine breakdown. If there is an engine breakdown for that particular thing, if any expenses incurred, such things. On the other hand, sorry, indemnify bailee comes where expenses is what I'm discussing. Indemnify bailee I'll discuss later. In case of gratuitous bailment, if the bailment is for the benefit of the bailer, whatever necessary expenses or extraordinary expenses incurred by bailee shall be indemnified, shall be compensated by bailer. Indemnify bailee. Indemnify bailee will happen in two ways. One, pay out the goods, he bails out the goods without any entitlement to bail it out. And if the original owner sues the bailee, then bailee shall ask for the compensation from the bailer. Second thing is for premature termination. In case of non-gratuitous bailment, if there is a premature termination and the benefit derived by the bailee is less than the expenses that he has incurred, then bailer has to compensate, indemnify him. And last duty of the bailer is to take back the goods. If he fails to take back the goods, he shall compensate for the expenses incurred by bailee for safeguarding the goods. This is what was discussed earlier. Continuing further, what we have is rights of bailer. First right is to put an end to the bailment. Bailee does any act which is inconsistent with the terms of the bailment. You had given the goods for your friend's personal usage. Your friend is renting it out, or your friend is giving it to someone else for using it. There is inconsistent usage, which is not in accordance with the terms of the bailment. In this case, the bailment can be ended by the bailer. The bailment is voidable at the option of a bailer. The bailment is voidable at the option of bailer. Bailer gets an option to avoid the bailment. Kulbhushan sent his car to Harish for repair. Harish gives that car to his friend Govinda for his personal use. Now Kulbhushan can terminate the bailment. The bailment can be put an end. Rights of the bailer. Second, demand return of goods at any time. Specifically, when the goods are gratuitous, when the goods are bailed out gratuitously. If bailment is gratuitous and for a specified time, bailer may demand return of goods. Bailer may demand return of goods before the specified time. But bailer shall have to indemnify bailee for any loss suffered by bailee. A lent his book to B for examination. Before examination, A demanded his book back. B has to pay extra 100 rupees for the book. B can recover this amount from A. So you can demand back the goods. However, if bailee suffers any loss, you shall compensate for this. Next, claim accretion. Accretion means increase. When you bail out a goods, say for example, you have bailed out a cow. Now, when the cow is with the custody of cow is in the custody of bailey, cow gives birth to a calf. Cow gives birth to a calf. Now, bailey cannot say, see, when the goods are when the cow was in my custody, the calf was born, so calf belongs to me. Bailey cannot claim it. It becomes the right of the bailier to demand back both the goods as well as accretion. Accretion means the increase that has happened on the goods. That is called as right to claim accretion. A pledges certain shares with B. While the shares are with B, company issues bonus shares, extra shares. Now A has all the right to demand back his original shares along the bonus shares that has been declared in his name. X uses cow to Y for safe custody for 1 month. During this time, cow gives birth to a calf. Now, Y is liable to return calf with cow. These are the examples which we can give for accretion in the goods, increase in the goods. Next, rights of bailor. Right against the wrongdoer, right against the third party. So you have given your car for repair. While the car is in garage, some third party comes and causes some harm to your car. Some third party comes and causes harm to your car. Now, even though the goods are in custody of bailey, you being the bailor of the goods have the right to file a case against the third party. You have the right to take action against the wrongdoer. Whosoever is causing a harm to your goods, you have the right to claim compensation from such person. You have the right to sue him, the wrongdoer. If a third party wrongfully prevents the bailey of the use of possession of the goods bailed or does them any injury, the bailor or the bailey, any of them may bring an action against the third party for loss or injury. So it is not that goods are with bailey, so bailey only can take an action, either bailor or bailey. Any of them can take an action. Any of them can take an action. X delivered his car to Y for 5 days for safekeeping. Z, a neighbor, broke the glass of the car. Now X or Y can claim the damages from Z. Either of them can claim the damages from Z. Right to sue bailey. Bailor has right to sue bailey for enforcing all the liabilities and duties of him. Suppose if bailey is not returning the car. Suppose if bailey does any harm to the car. For all his duties and liabilities, bailor has the right to sue bailey. Last one is right to compensation. If any damage is caused to the goods bailed because of unauthorized use of goods or unauthorized mixing of goods, the bailor has the right to claim compensation for the same from the bailey. Bailor can claim compensation from bailey. These are the rights of bailor which we can discuss. So to summarize, summary sheet is here. Rights of bailor, termination of bailment, demand return of goods anytime, claim accretion in the goods, addition in the goods, right against third party, right to sue the wrongdoer, right to sue the bailey, right to claim compensation. These are the rights available for bailor. These are the 6 different rights available for bailor. Please give me a confirmation whether the things are clear to us. Everybody, confirm if it is clear. Shall I you? Next thing that we need to discuss is duties of bailee. What are the duties of bailee? See, rights of bailer should be duties of bailee. Simple. Of course, there are some additional things we have to keep in mind. There are few important points here. Duties of bailee. First one is to take reasonable care of goods. The word used is reasonable care. Reasonable care. When I say reasonable care, what does it mean? If it was your own goods, how much careful you would have been on that goods? Same amount of what we say, same amount of precautions, same amount of carefulness you should show with respect to bailer's goods. If the goods were yours, your own goods, how much careful you have been? Same amount of carefulness you should show on the goods of bailer. Say, for example, bailer has given you the goods. Golden ornaments. Bailer has given you some golden ornaments for a safe custody. He has asked you to keep it safely. Hello, hello. Please give me a confirmation if you can hear me clearly. I'm audible, right? Please make sure that you can hear me clearly. Yes, thank you. Thank you for confirmation. Because here everything went blank. I could not see anything. Like the screen, everything was not visible. Yes. Let us restart. Say your friend gives you jewelries for safe custody. What you do is you keep those jewels at your place along with your own jewels. Just like how you maintain, how you safeguard your jewels, you keep it at same place, same locker, and then there is a theft. Then there is a theft. Both of your jewels are lost. Your friend cannot say that you have not taken care of it. Because law requires you to take reasonable care. When a reasonable care is ordered, you should be taking reasonable care. Reasonable care means if it was your own goods, what care you would have taken, that would amount to reasonable care. That would amount to reasonable care. But let us say your friend gives you some jewelries. You keep it at your house. But your jewelries are kept in bank now. Your friend had given it for safe custody. You keep it at your place. But your friend, so you keep your jewelries at your house. I mean, you keep your jewelries at bank, but friends' jewelries are kept at your house. Now there is a theft. and all jewels of your friends are lost. Friends' jewelries are lost. Now you will be held liable because you have not taken reasonable care. If I have to say you have taken reasonable care, the care should be equivalent to what you take for your own goods. If the goods were yours, what care you would have taken? Similar care you have to take. Only then it amounts to reasonable care. Otherwise, it is not reasonable. A lends his car to B. B does not park the car at proper parking. The car was stolen. B is liable to compensation because he left the car as it is. He did not take the precautions. Whatever carefulness he should have taken, he did not take, because of which the car is lost. Here, there is a clear fault. There is a clear fault of the bailee. If in the above case, B parks the car at proper parking, even the car was stolen, even then the car was stolen, B is not liable to compensate. B is not liable to compensate. This is what the fact says. B is not liable to compensate. Is it clear? Hello class, please make sure you have understood the concept clearly. Is it clear? Yes. Yes. Next, not to make any unauthorized use of goods. Let us say Deepak has given his car to Akshay. Deepak has given his car to Akshay for the purpose of Akshay's personal usage. Now, what Akshay does is, Akshay gives this to someone else for their usage. It was purely given for the personal usage of Akshay. Now, Akshay, without the authority or without the permission of Deepak, gives it to some other person. It amounts to unauthorized usage. He's doing something that he is not authorized to do. What he is not authorized to do. When this happens, bailee will be liable for the unauthorized usage of the goods. For this unauthorized usage, whatever loss may happen, bailee will be held personally liable. Bailee will be held personally liable. This is what the point states. Unauthorized usage. Bailment becomes voidable at the option of bailer. And along with that, bailee is liable for any loss or damage, even if such loss is caused due to an act of God. If the unauthorized usage is there, then who does the act or how the particular loss happens, that becomes immaterial. That becomes immaterial, and bailee shall be held liable for the loss caused due to unauthorized usage. A gives his watch to B to be used by B only. Afterwards, B gives that watch to his brother without informing A. Without informing A. Taking due care, watch was stolen. B will be liable to compensate it. Even if you have taken the reasonable care, still you will continue to be liable. You will continue to be liable. That is what the point states. Next is about mixing of goods. Bailer has given his goods to bailee. Bailee has no permission to mix the goods with his own. Bailer's goods cannot be mixed with bailee's goods. Bailer has no permission to mix the goods. Now, suppose if bailee mixes the goods of bailer along with his own goods, what will be the consequence? That is discussed in these three sections, 155, 156, and 157. When bailer gives the goods to bailee, let us say Baler gives 50 kgs of sugar, which costs 25 rupees per kg. 50 kgs of sugar, which costs 25 rupees per kg, is given to Bailey for safe custody. Now, Bailey also has some stock of sugar. Bailey also has some stock of sugar. Let us say 20 kg of sugar, but little bit inferior quality of sugar it is, which is at 15 rupees per kg. Bailey's goods are 15 rupees per kg sugar. Now, first situation what we are analyzing is very simple. If Bailey takes the consent of Baler and mixes it, Bailey mixes the goods with the consent of the Baler. Since Baler also has consented, both the parties are in agreement for doing this. So what happens is both Baler and Bailey will have interest in the proportion to their respective share in the mixture. So now there becomes 70 kgs of sugar, 70 kg of sugar to the extent of 50 kg. Whenever it is sold to the extent of 50 kg, Baler will have the right. To the extent of remaining 20 kg, Bailey will have the right. In the proportion of their respective share in the mixture, they will get the right. When the mixing happens with the consent, when the Bailey mixes the goods with Baler's consent, with the Baler's consent. Next is mixing of goods without the consent of Baler, without the consent of Baler. See, in this case, Bailey mixes his goods with Baler, and it is not possible to separate goods, inseparable, because you cannot identify which sugar belongs to whom. So, in this case, Bailey shall compensate Baler for the loss. That means 50 kgs into 25 rupees. That is the loss which Baler suffers. That loss should be compensated by Bailey to Baler when the goods are inseparable, when you cannot separate the goods. On the other hand, suppose if rice and tur dal or something that you can separate is mixed without the consent of Bailey, then it becomes the duty of Bailey to separate the goods and also to bear the expense of the separation. He shall bear the expense of the separation, and also due to that mixing, if any consequential loss occurs to Baler, that loss shall also be compensated. The loss shall also be compensated. This is with respect to mixing of provisions with respect to mixing of goods. One of the important sections where normally they test in the examination. Normally they test mixing of goods frequently. It's not that only this area will be tested, but this is tested frequently. So please make sure you have understood this concept clearly. Then I proceed for the next with respect to mixing part. Next is duties of Bailey. They have given some examples with respect to mixing of goods. They have given some examples. Let us try to analyze this. Mudit sends 100 packets of MP wheat flour to his friend Rajat to be delivered to Naman. Unfortunately, staff of Rajat mixed those packets in Godown with packets of other brand flours packets. Now Rajat is liable to pay the expense for separating the packets if it is separable. Rahul sends 100 kgs of MP wheat to his friend Deepak to be delivered to Kishan. Unfortunately, staff of Deepak mixed that wheat with other quality wheat. Wheat cannot be separated now. Deepak is liable to compensate Rahul for loss of wheat. Deepak is liable to compensate. This is what it states about mixing of goods. Next duty of bailee is to return the goods. It is the duty of bailee to return or to deliver the goods according to the direction of the bailer without demand on expiry of the time fixed or when the purpose is accomplished. If the particular bailment is time bound, once the time is over, even if the bailer has not demanded back the goods, it becomes the duty of the bailee to return the goods back to him. Or if the particular bailment is for some purpose, one accomplishment of purpose, it becomes the duty of bailee to return the goods to the bailer. If he fails to do so, he is responsible to the bailer for any loss, notwithstanding the exercise of reasonable care on his part. Let us say you give umbrella, takes umbrella from you, urgent. He says he'll return it back after a week. ಒಂದು ವಾರದಲ್ಲಿ ಈ umbrella ವಾಪಸ್ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ. He fails to return it after a week. After completion of second week, 1 week over, second week, what your friend does is he is bringing back the umbrella to you, and suddenly he slips and falls and breaks the umbrella. He falls, in his hand there is umbrella, and umbrella also breaks. Now, even though he has taken reasonable care, since he has not returned the goods as according to the time prescribed, he will be liable to compensate you for the loss of umbrella. He will be liable to compensate you for the loss of umbrella. Similarly, there is one more example given there. A took the book from his friend B for 3 days. After 3 days, A does not return the book to B. Even taking the due care of the book by A after end of the period, the book is picked and torn by a monkey. Now, A will be liable to compensate B. A will be liable to compensate B. So, no doubt in that. Even if you have taken reasonable care, if you are having the goods after the due date, then it becomes your duty to compensate if any loss happens to such goods. This is with respect to duty of bailee to return the goods. Next, return accretion in the goods. We have already discussed this. Whenever there is accretion goods, it becomes the duty of bailee to return the accretions also. Same like how we have right of bailer to take back the accretion. Here we say duty of the bailer to return the bailee to return the accretion. Duty not to set up adverse title. Adverse title means title against the ownership of bailer. That means when you bail out the goods to a bailee, bailee cannot sell it to any other person. Bailee cannot sell it, because that amounts to setting up adverse title. That amounts to setting up adverse title. The bailee is under a duty not to do any act which is inconsistent with the title of bailer. He should not set up his own title or title of a third party on the goods bailed to him. Kulbhushan sent his car to Hirish for repair, used that car to his friend Govinda for personal use. This is inconsistent usage. Now, if suppose the car which you have sent for repair, if it is being sold by the garage owner, it will not amount to valid sale, because bailee cannot set up an adverse title. The title setup is adverse. Adverse title is not possible, not permitted. These are the duties of bailee. These are the duties of bailee. Last part we need to discuss is rights of bailee. Rights of bailee. Before I go for rights of bailee, please make sure you've understood all the duties of bailee clearly. Duties of bailee, whether it is clear. Please give me a confirmation. Let us continue to this part. Rights of bailee. What are the rights of bailee? One by one, we have few rights. 7 rights are there. Let us discuss one by one. Right to deliver the goods to any of the joint bailers. So if there are more than one owners who have jointly bailed the goods, there's a car, say we say this Kirik party car is. Kirik party car has more than one owner. There are, let us say, 4 owners are there for the car. Now, when these 4 owners jointly bail the car, where there is no clear instruction as to whom the goods must be returned, bailee can return it to any one of the joint owner. If bailee returns it to one of the joint owner, that will be more than sufficient. So that is the first right available with the bailee. Right to deliver goods to any of the joint bailers. Any of the joint bailers. If several joint owners bailed the goods, the bailee has a right to deliver them to any one of the joint owners. Multiple owners will be there, out of them to any one of the joint owners. Unless there was a contract to the contrary. That means if it is specifically agreed that the goods must be returned to this joint owner only, then it becomes compulsory to return it to him. However, where there is no such agreement, the bailee can return it to any one of the joint owners. Multiple owners, out of multiple owners, any one of the joint owners, if it is returned, that will be more than sufficient. A, B, and C are the joint owners of a car. They delivered it to hire to D for 1 month. After the expiry of 1 month, D may return the car to any one of the joint owners, either to A or to B or to C. If there is a specific agreement which says it must be returned to A only, then it must be returned to A only. Otherwise, it may be returned to any one of the joint owners. Any one of the joint owners. Next, right to indemnify. Bailee has right to be indemnified. Suppose if bailer has no right to bail out the goods, bailer has no rights and still he has bailed the goods, and now bailee suffers loss because of this. You don't have a car, you have taken someone else's car. Without the other person's permission, you are bailing it out. Now that original owner sues bailee, saying that you are unauthorizedly using my car. Now bailee can ask for compensation from me because I did not have the title. That is why he is suffering. So he has the right to be indemnified. The bailer has no title to the goods, and as a consequence, bailee suffers some loss. Bailee has the right to be indemnified. He can get indemnified. Next, right to compensation in case of faulty goods. We have already said gratuitous bailment, non-gratuitous bailment, fault, disclosure of fault, everything is discussed. Same thing, we are writing it as right. A bailee is entitled to receive compensation due to failure of the bailer to disclose any faults in the goods known to him. This is in case of both gratuitous or non-gratuitous. Both gratuitous as well as non-gratuitous. Both case of non-gratuitous and non-gratuitous. However, in case of non-gratuitous, whether the fault is known or not known, irrespective of that, if any default is there in the goods, if any fault is there in the goods, it becomes the duty of the bailer to compensate. So bailee has the right to get the compensation. The bailer will be liable to compensate even though he was not aware of the existence of such fault. We have already discussed this in the above provision. We have clearly discussed this in the above provision, if I am not wrong. So moving on further, rights of bailee. Next important point. Where the bailment is non-gratuitous, bailee has the right to claim extraordinary expenses, and bailer shall compensate the extraordinary expenses. In case of gratuitous bailment, see, that is what I said. No, duties of bailer is right of bailee. Duties of bailee is right of bailee. So all these points are already discussed. That is why we see a lot of similarities. In case of gratuitous bailment, necessary expenses as well as extraordinary expenses. If it is for the benefit of the bailer, then it becomes the duty of the bailer to compensate. Bailee will get the right to compensate, get compensated. So this is the part. Next, right against the third party. Now I said, you have given a car for repair. While the car is in the garage, some third party causes some damage to the car. Now what happens is, being the owner of the goods, bailer can sue the wrongdoer, or you being the person having the possession of the goods, law also says even you can file the wrongdoer as if you are the owner. As if you are the owner. So when goods are in your custody, even though you are not the owner of the goods, when goods are in your custody and a third party comes and destroys the goods, third party injures the goods, third party prevents you from using the goods, you, even though not the owner of the goods, law says that you'll be deemed owner in that situation, and you have all the right to sue the wrongdoer. You have all the right to sue the wrongdoer. If a third party wrongfully prevents the bailee of use of possession of the goods failed or does them any injury, bailer or bailee may bring a suit against third party. Bailer or bailee, any of them is wrongdoer. Next one, right to apply to the court to decide the title to the goods. Who is the owner? Sir, someone has billed you the goods, but later on when you're going to return it, there is a dispute between two people. One person is saying this is my goods, the other person is saying this is my goods. There is no clarity as to who is the owner. Now, you being the bailee, you have to return the goods. So what you can do is, you can apply to court. You can straight away go to court and say that, sir, I don't know who is the owner. Please decide and tell me who is the owner, then I'll return the goods. So where there is a conflict as to title, where there is a conflict as to who is the true owner of the goods, bailee has the right to go to court, apply to the court, and ask the court to decide who is the owner of the goods, right? To apply to the court to decide the title to the goods. If goods bailed are claimed by person other than the bailer, the bailee may apply to the court to stop its delivery and to decide the title of the goods. Example A. A dealer in TV delivered a TV to B for using in summer vacation. Subsequently, C claimed that TV belonged to him as it was delivered only for repairs to A, and thus B should deliver it to him. In this case, we may apply to the court to decide the question of ownership of the TV so that he may deliver it to the right owner. He may deliver it to the right owner. Is it clear? These are the general rights available for bail. One more right is to be discussed, before which please give me a confirmation whether these things are clear. Whatever I have discussed already, whether it is clear or super. Let us continue to the next part. Last right of the bailee to be discussed is right of lien. See, we have come across this word lien in Sale of Goods Act. When we have discussed the provisions of Sale of Goods Act, we have discussed about this provision of lien. Now, what exactly do we mean by lien? What is meant by lien? Lien means right to retain some other person's property. Right to retain some other person's property is called as lien. This is what is called as lien. Now, in case of bailment, what exactly do we mean by right of lien? When can right of lien be exercised in case of bailment? What exactly do we mean by right of lien in a bailment case? Let us say you go to a bank for obtaining loan 1, unsecured, rupees 5 lakh. You take a loan of rupees 5 lakh from a bank without any security. After some days, you go to the same bank and you take loan number 2, secured with jewelry, rupees 1 lakh. After some days, you repay this. See, this is also lien only. Giving jewelry for loan purpose is also a lien. You are delivering the goods for some purpose, on completion of which the goods will come back to you. So even this will be considered as lien only. Even this will be considered as bailment only, kind of bailment only. Now, can the bank retain this jewelry towards loan 1? Since you have not repaid loan 1, can the banker say, I will not give the jewelry until you repay the loan 1? Till you repay your loan 1, I will not return your jewelry. Can the banker say this? See, persons like banks have this special power where they can retain the goods towards the dues that they are required to receive, towards any dues that they have the right to receive. Any dues. Any dues. So where even if the jewelry is given for loan 2, since loan number 1 is not recovered, bank has all the right to retain jewelry or till the loan 1 is repaid. This right which is available with bank is called as general lien. We consider it as general lien. Towards any amount due from a person, you are retaining the goods. Any amount due from a person, you are retaining his goods so that he repays it and then collects back the goods. This is called as general lien. This right is called as general lien. Not available to every person. This is available to only 5 persons who are bankers, factors, wharf ingers, policy brokers, attorneys of law. I repeat, general lien means retaining anything that belongs to some other person towards recovering of any dues that is due from such person, towards recovery of any debt which is due from such person, any amount that is due from such person. This right is called as general lien. However, we cannot randomly retain any goods of any person towards any dues. It is only 5 people who have this right to retain the goods. Those 5 people are bankers, factors, wharf ingers, policy brokers, and attorneys of law. Bankers means all the banks, what we see. Factors are none other than agents. Factors means agents. Wharf ingers. Wharf means dock, harbor. The person in charge of that particular wharf is called as wharf inger. He is the chief of that particular dock. Such person. towards any dues from a person. Policy broker means person who helps you in obtaining insurance policies. Attorneys of law are your advocates. These five people have the right to retain your goods towards general balance in your account, towards any balance that is due from your account. This is what is called as general lien. This is what we call as general lien. Other than these five people, when a person does any labor on a particular goods, that is to say, for example, a tailor. A tailor stitches a clothes to you. Now, once he completes his work, if you fail to pay the charges, lawful charges that is due to him, if you fail to pay the lawful charges that is due to him, his labor charges, whatever is there, till you pay such charges, he has the right to retain the goods. Till you pay the charges, he has the right to retain the goods. But you should always understand that should be one-to-one relationship here. One-to-one relationship should be there. One-to-one relationship means for what thing he has done the work. Towards that, if any money is due, he can retain such goods. Say first time you went for stitching a suit. You got it stitched. He gave the goods to you, but you failed to pay the tailoring charges. Second time you go to him. Second time you are paying him the charges. But he cannot retain the goods saying that last time's charges is pending until it could kill now. Once it is lost, it is lost. So, particular lien means there should be one-to-one relationship where one person has exercised skill and labor on a particular goods. Towards that skill and labor, he has the right to retain the goods. This is called as particular. General lien concept, that particular thing is not there. General lien, there need not be that quid pro quo, one-to-one relationship. Yes. So let us briefly discuss this. Lien is the right of a person to retain goods belonging to another until his claim is satisfied or some debt due to him is repaid. Types of lien: general lien, particular lien. General lien, right to retain the goods, not only for the demands arising out of the goods, restrained, retained, but for general balance of account in favor of certain persons. General balance means for any balance that is to receive, any balance that is to be received. That is called as general lien. The right is available to bankers, factors, wharf ingers, policy brokers, and attorneys of law. Particular lien means right to retain only particular goods in respect of which the claim is due. Claim towards skill and labor. Claim towards skill and labor. With this, we conclude the discussion on rights of bailor and bailee, duties of bailor and bailee. Is it clear? Please make sure you have understood this. Then I can proceed ahead for the next thing. Next important concept here is modes of termination of bailment. How will bailment come to an end, or how will bailment be terminated? First one is on expiry of stipulated period, predefined period. If the bailment is for specific period, once that period is over, the bailment will come to an end. On expiry of stipulated period. Second one is on accomplishment of specified purpose. If the bailment is for some purpose, once the purpose is completed, the bailment comes to an end. X hire certain tents. See, Shamyana, we put no. Once your marriage function is over, the bailment is over. You cannot retain it. You have to return it. The person will come and collect it back. Bailey does anything inconsistent with the conditions. Where Bailey fails to fulfill the conditions, bailier can terminate it at any time. A gives his horse to B for his own riding. B gives the horse to his brother. A can terminate the bailment. Voidable. The contract becomes voidable. That's what we see. Then, in case of gratuitous bailment, it can be terminated by bailier any time. But only thing is, due to premature termination, if bailee suffers any loss, expense, then it becomes the duty of the bailier to compensate the loss. Death. In case of gratuitous bailment, death of bailier or bailee will put an end to the contract of bailment. Destruction of subject matter. The subject matter itself is destroyed. If the particular goods itself is destroyed, the bailment ends. Last thing that we need to discuss under bailment is provisions related to finder of lost goods. See, law says that under quasi-contract, law states finder of lost goods should take reasonable care of the goods. Finder of lost goods should try to find the true owner. And once he finds the true owner, finder of lost goods must return the goods to him. So, till the true owner is found, law considers finder of lost goods as bailee. Law puts him in the position of bailee. That is why there are certain rules which he must observe. That is why this is specifically discussed under this provisions of bailment. Law considers finder of lost goods as bailee. So law imposes certain obligations on finder of lost goods. So certain provisions of bailment will also be applicable for finder of lost goods. Certain provisions of law will be applicable for finder of lost goods. Shall we discuss this? Please give me a confirmation so that I can ensure you are listening to the class. Please make sure you are listening. Shall we? Yeah. Finder of lost goods. Finder of lost goods is a person who finds goods belonging to another and takes them into his custody. He is subject to same responsibilities as a bailee. Duties of finder of lost goods: to take reasonable care of goods, not to mix the goods with his own goods, to find the true owner, reasonable effort. He should put reasonable effort to find the true owner, not to use the goods for his personal purpose, to return any increase in the goods, accretion if any. Must be. Now, when can finder of lost goods retain the goods? When can he exercise right to liability? The finder of lost goods can retain the goods against the owner until he receives compensation for the trouble and expense voluntarily incurred by him to preserve the goods. So now what happens is finder of lost goods has to take reasonable care. Since he has to take reasonable care, the possibility is that he might have incurred certain expenses. Now, till the expense is paid, he gets the right to retain the goods. Now, the beauty of the provision is that it says he will not get any right to sue the true owner where he has incurred some lawful expense to take reasonable care of the goods. Finder of lost goods does not get any right to sue the true owner for that particular expense, recovery of that expense. However, he may retain the goods till the expenses are paid to him, till the expenses are clearly paid to him. However, where the true owner has declared a reward, any person who finds these goods will be rewarded. If such a reward is announced by the true owner, if such a reward is announced by the true owner, then the finder may sue for such a reward and may retain the goods until he receives it. For the reward amount, if there is any specific reward announced for the reward amount, he can retain the goods as well as he can sue the true owner till the true owner gives the reward amount. He can retain the goods. He has all the right to retain the goods. Last one is, since the finder of lost goods is not the true owner, he will not have the right to sell it. But under certain circumstances, he will get the right. What are the circumstances? Where true owner cannot be found with reasonable diligence. Sir, I made reasonable search, but I could not find the true owner in that case. Or true owner is found, but he refuses to pay the lawful charges of the finder. This lawful charges, whatever is there. No, if he refuses to pay, in that case, the finder may sell it when the goods are in danger of perishing or losing greater part of its value, or when the lawful charges of the finder in respect of the goods found amounts to 2/3 of the value of the goods. So, finder of lost goods gets the right to sell it. Number one, where he cannot find the true owner even after searching for him. Or number two, where true owner is found, but the true owner refuses to pay the lawful charges of the finder. In these two cases, either of these two cases, if the goods are perishing in nature, that means the value of the goods are going to lose in the near future, or if the expense incurred by the finder amounts to 2/3 of the value of the goods, in such a case, a finder of lost goods will get the right to sell the goods. He will get the right to sell the goods. So with this, we conclude the provisions on contract of bailment. Contract of bailment comes to an end here. Please give me a confirmation that you have understood the provisions of contract of bailment clearly. Everybody is required to give a confirmation. Let us see how many students are there. Of course, here they are showing 28, but how many students are actively participating in the session? I just want to ensure. Please make sure you are giving a response to me in the chat box. After which I'll be giving a brief break of 5 minutes. Then I'll again continue to contract of pledge. Contract of pledge is a very small area, which is continuation of contract of bailment only. So since it is related topic, I'll be covering it immediately. But before I proceed for bailment, I'll be giving you a small break of 5 minutes. And then we'll continue the same. Let's take a small break of 5 minutes here. You can relax yourself, you can stretch yourself, and then come back and we'll discuss on pledge. Hardly it will take half an hour to discuss. We'll quickly finish it. Let us restart. So here we go. Next provision that we need to discuss is about pledge, a very small area to cover. Now let me explain you what exactly pledge is so that you will understand how pledge and bailment are same. Let us say Pranjal wants to open an office. So she needs some loan. She is a chartered accountant. So she needs a loan to open her office. Once the office gets set up, she'll get clients and then she'll repay the loan. So she's thinking about going for a bank and taking a loan. So she goes to a bank. Bank agrees to give a loan of 2 crore rupees to her. But bank asks her to deposit her jewelry with the bank. She's actually going for a jewel loan. Because anyhow, she is newly qualified chartered accountant. Now urgently she doesn't need jewelry. So what she's thinking is, let me deposit the jewelry with the bank. I'll take loan now, build the office, clients will come. Then let me do the business and then I can anyhow get the jewels back. Here, what Pranjali is actually doing is, Pranjali is delivering the goods to bank. Pranjali is delivering her jewels to bank for a purpose. The purpose is security. She's actually giving this jewels to the bank as security for the loan which she is going to take. On satisfaction of this particular debt, once she repays this, the jewelry will be returned to her. The jewelry will be returned to her. Nothing but bailment only. Delivery of goods for a purpose, on completion of which the goods shall be returned back to the owner. Same way here also, but here the goods are delivered for specific purpose, not for a general purpose. The goods are delivered for one specific purpose, and that specific purpose is as security. The goods are given as security. So where goods are given as security, either for payment of a debt or for performance of promise or for performance of any promise, such a contract of bailment or such a type of bailment is called as pledge. Such a type of bailment is called as pledge. Bailment of goods as security for payment of debt or performance of promise is called as pledge. Parties which are involved in pledge are two parties, bailer and bailee. Here bailer is called as pawner. Why pawner, sir? Why pawner? Because pledge is also called as pawn. The contract of pledge is also called as pawn. You might have seen this show that comes in History TV 18, Pawn Stars. That entire show is doing this pawn business. That is why the parties are called as pawner, Pranjal who deposits, or we can also call them as pledger and pledgee. If you observe all the special contracts that we have been discussing, everywhere we can find that parties will have a name. Parties will have a name in majority of the special contracts. First thing that we discussed was indemnity, indemnifier, indemnity holder. Second thing was your guarantee. Their principal debtor, creditor, surety. Then we discussed bailment, bailer and bailee. Now we are discussing pledge, pawner and pawnee, or pledger and pledgee. Next, what we are going to discuss is agency. In that, principal and agent. So like this, in every special contract, we have parties. associated with the contract. Now, Pawnee is nothing but Bailey. So his rights are almost similar with Bailey only. Almost similar with Bailey. Of course, there are few alterations here. So what are those? We have to see. Retain the pledged goods. Pawnee may retain the goods pledged for payment of debt, for interest of any debt, and all necessary expenses. So, for what and all things, Pawnee can retain the goods. Number one, for payment of debt, till the loan is repaid, the goods can be retained. Not only for repayment of loan, for interest due on that particular, so not only for 2 crore rupees, interest on that 2 crore rupees. For that purpose also, the goods can be retained. Or suppose, say, the bank incurs some necessary expenses, maybe for safeguarding that particular jewelry. Bank may incur some insurance. Bank may have a locker rent. Now, for recovery of that necessary expenses also, goods can be retained. So, for 3 purposes, the goods can be retained till the debt is repaid, till the interest on the debt is paid, and till the necessary expenses for preservation of goods are paid. Till these 3 things are paid, the goods pledged can be retained by the pledgee. Now, when goods are pledged for loan 1, can the same goods be retained for loan 2 also? And thereafter for every subsequent loan, loan 3, loan 4, can be retained. It may be retained if there is a specific agreement between the parties. What does it say is, goods pledged can be retained for subsequent debt also, provided there is a contract between pawner and pawnee, or pledger and pledgee. Next, last one is, if pawnee incurs any extraordinary expenses, rarest of the rare circumstances, we come across extraordinary expenses. If at all extraordinary expenses incurred, law says that towards those extraordinary expenses, the goods cannot be retained. The pawnee can sue owner for recovery of those extraordinary expenses. So normally pledgee will not incur any extraordinary expenses. If at all it happens so that he has to incur some extraordinary expenses, then for recovery of those extraordinary expenses, pawnee cannot retain the goods, but pawnee can only sue the pawner. These are the 3 rights available over and above the rights of bailey. Along with this, rights of bailey should also be considered. Next, rights of pawnee. Continuing. Last right is when the pawner defaults. When the pawner, the person who has pledged the goods, defaults in repayment, what can be done? If the owner makes default in payment of debt within the specified time, the pawnee may bring a suit against the pawner upon the debt and retain the goods as collateral security. Either pawnee can sue him and retain the goods till the matter is decided as collateral, as security, or he can sell the things pledged on giving reasonable notice to pawner. So if Pranjal has pledged her jewelry and taken a loan, tomorrow if Pranjal fails to repay the debt as per the terms of the contract. What can banker do is banker will get two options. One, file a suit in the court and retain the goods till the matter is settled. Or banker can give a notice to Pranjal saying that will you repay it or we are going to sell it. Either you repay the loan or we are going to sell it. After giving the notice also, if Pranjal fails to reply or Pranjal fails to return the pay the amount, pay the debt amount, then the particular banker, that is the pawnee, will proceed to sell the goods. In such case, if the proceeds of such sale, so 2 crore was the loan, let us say interest is 20, total amount comes to 2.2 crore 20 lakhs. This is the amount due from Pranjal. But when the jewels are sold, let's say the jewel fetches 3 crore rupees. What to do with the excess amount? The 80 lakh rupees excess there. What to do with that? Greater than the amount so due, pawnee shall pay over the surplus to pawner. Whatever the excess amount is there, it shall be paid to pawner. However, if the jewelry fetches only 1 crore 80 lakhs, then pawner is still liable to pay the balance. Pawn is still liable to pay the balance. You can hold pawner liable for the balance. This is important here in this particular discussion. This particular slide is very, very important. Rights of pawnee. Please make sure you have understood it. Sorry for the inconvenience. I'm getting the hiccups. Please let me know if the things are clear to you. This provision is slightly different from Sale of Goods Act. In case of Sale of Goods Act, if the buyer is not paying the amount, you will resell it. You keep it yourself. Deficit, you can ask the buyer to pay. Here it is not that way. Surplus, you will give it back. Deficit, you can collect it. Different from Sale of Goods Act. Little bit different from Sale of Goods Act. Yes. Next one is rights of pawner, same as that of bailer. Terminate bailment, you can put an end by repaying loan. Demand return of goods anytime. Claim accretion, right against third party. All these rights same as bailer he gets. One more right he gets is redemption of goods before sale. See, I said Pranjal has defaulted in repayment of loan. Banker has sent a notice to Pranjal asking her whether she'll be paying it or should banker proceed for sale. That means even after due date, Pranjal has a chance. Pranjal can even pay the amount. Due date ಆದ್ಮೇಲೂ ಕೂಡ Pranjal has the right to pay the amount plus some extra interest she will have to pay, and then she has all the right to recover back the goods that is being pledged. She can recover back the goods that is being pledged. When owner makes default in payment of debt or performance of promise, he still has a right to redeem the goods pledged at any subsequent time before the pawnee sells them, but he has to set additional expenses to the pawnee that arose due to his default. So, unlike breach of contract, what we do is one more chance will be given to the pawnee. Pawner. Pawner has the right. Even after due date, pawner can make the payment and he can recover back the goods. Redemption means to recover back the goods by making payment of debt or performance of promise. Only thing is he will have to pay the additional expense. That's it. Additional expense means some extra interest he will have to pay for delay. Some extra interest he will have to pay for the delay. Speaking about the duties, I'll show it on the screen. You can take a note of it. Same thing, same duties as owner and pawnee, same like bailor and bailey. Pawnee, bailey, owner, bailor. So please take it into consideration. The last topic to be covered in this particular part is pledge by non-owners. When can persons who are not the owner of the goods do a valid pledge? Same like Sale of Goods Act. A person who is the owner of the goods can pledges goods. But there are certain exceptions where even if the person is not the owner of the goods, he can make a valid pledge. What are those? Almost similar to what we have discussed in Sale of Goods Act. In Sale of Goods Act, we say this as sale by non-owners. Here we consider it as pledge by non-owners. Almost similar circumstance. So let us discuss this one by one. First one is pledge by mercantile agent. When the agent who is in possession of goods of principal, with the permission of principal, he has the possession of the goods. Maybe he may not have the authority to pledge it. Still, in the ordinary course of business, for the purpose of business, if he pledges the goods, it becomes a valid pledge. So what are the conditions? You see here. A mercantile agent who is in possession of the goods or document of title. Document of title is nothing but ownership document. Ownership document of the goods. Mercantile agent who is in possession of the goods or document of title. He is having this possession with the consent of owner. He can pledge them while acting in the ordinary course of business as mercantile agent. Mercantile agent means business agent. So ultimately what they are saying is you are an agent appointed by a principal for doing some business activity. You have owner with his consent only. But let us say you do not have any authority to pledge the goods. You don't have the authority to pledge the goods. For the business purpose, you are pledging the goods. Maybe for business purpose, you may need some short-term loan. For that purpose, you are pledging the goods. Now, when you are acting for the business purpose, if you pledge the goods which you have with the permission of the owner, goods which are available with you with the permission of the owner, even though you do not have the authority to pledge the goods, the pledge that you do will be valid. The pledge that you undertake will be valid pledge. This is what the law says, as if it were made with the authority of the owner. But only thing that is required is the pawnee should have acted in good faith. The pawnee should act in good faith. Pawnee means the person who is bailey or person who is giving the loan for me. If he is acting in good faith and he has no authority, he has no notice that owner had no authority to pledge the goods, then it will constitute a valid pledge. In such a circumstance, the pledge will be valid. In such circumstance, the pledge will be valid. Second one, pledge by possession, pledge by person in possession of voidable contract, goods under voidable contract. When you are holding goods which you obtain under voidable contract, when owner has obtained possession of the goods under a voidable contract, that is maybe coercion, undue influence, because of this reason you obtained the goods. The pledge created by him will be valid provided that contract has not been rescinded before contract of pledge. Before you pledge the goods, if the contract is not rescinded, if the contract is not taken back, if the contract is not cancelled, and pawnee acts in good faith without the notice of owner's defect of title, without the notice of owner's defect of title, that means in such a case, the pledge will be valid. Only after settling the dues, the goods can be released. Till then, even if the contract is cancelled, after pledging the goods, if the contract is rescinded, still the pledge will be valid, and only after settlement of dues, the goods can be taken back. This is pledge by a person in possession of goods under voidable contract. Third one, pledge by owner who has only limited interest in the goods. Let us say you are not the owner of the goods, but you have some interest in the goods. Some interest in the sense you are not the absolute owner, but you still have some right in that particular goods. They have given an example. Let us say A pledges his jewelry worth 1 lakh with B for loan of 70,000 rupees. So for a loan of 70,000 rupees, A has pledged his jewelry with B. The value of the jewelry is 1 lakh, but the loan taken is 70,000 rupees. What B does is, B further pledges it with C for 90,000 rupees. B is taking a loan of 90,000 rupees and further pledging it with C. Now, the pledge between B and C is valid only to the extent of 70,000 rupees. Because B's interest in that particular pledged jewelry is 70,000 rupees only. That is limited interest. Even though B is not the owner, he will get limited interest, and that to the extent of that limited interest, the pledge will be valid. When a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that limited interest. Whatever the limited interest is there, to that extent, the pledge will be valid pledge. Pledge by co-owner in possession of the goods. Multiple owners are there. One person, one of the owner who has the possession of the goods, pledges it. The pledge will be valid. The pledge will be valid pledge. Where goods are owned by many people and with the consent of other owners, the goods are left in the possession of one of the co-owners. Even though he has not taken the other person's permission, if he pledges the goods, and that particular pledge will be valid pledge only. That pledge will be considered as valid pledge. And last one is pledge by seller or buyer in possession of the goods. Suppose if goods are available with the seller even after the sale is complete, or suppose if the goods are available with the buyer with the consent of seller even before the sale is complete. In both the cases, if they pledge the goods and pawnee obtains the goods in good faith without being aware about this particular fact that the goods are already sold or goods are yet to be sold, then the pledge will be valid pledge. The pledge will be valid pledge. So A buys a cycle from B, but leaves the cycle with seller itself. B then pledges the cycle with C, who does not know of the sale to A and acts in good faith. Here, even though the goods is sold, even though seller is not the owner of the goods, pledge, to the extent of pledge, the good pledge is valid. Only after repaying the loan, the particular goods can be taken. Otherwise, the goods cannot be released from C. This is pledge by seller or buyer in possession of goods. So these are the 5 different scenarios where even if you are not the absolute owner of the goods, you can pledge the goods and the pledge will be valid pledge. Please give me a confirmation if this is clear to us, everybody. Okay. So with this, we conclude one more unit of this particular contract act, that is bailment and pledge. I have not unnecessarily elaborated the discussion. I have kept it very limited, purely from the examination perspective, so that those students for whom these are additional topics, they will have good amount of knowledge sufficient for writing their examination. So what you are supposed to do is, these video lectures will be available in the Trisha classes channel. You can refer to them at any time whenever you are in doubt. Make sure that you read the institute material along with these video lectures, so that the things will be very clear for you and you will be in a position to answer the questions that are going to come up from these areas. So these are going to be your additional scoring areas, and these are the areas where you can score easily. So please make sure that you cover these topics 100% and you write the examination, right? So as per our schedule, whatever the current schedule is there, for now we are stopping with this particular additional classes on law. Again, these classes will continue with respect to law. I'm saying other subjects will continue even tomorrow. Tomorrow onwards, other subjects are there. As far as law is concerned, we'll be meeting back again in first week of April. We'll be meeting back in first week of April, and we'll be finishing off the remaining topics. We have two topics remaining. One, your contract of agency. One more is negotiable instrument act, which will take around 3 to 4 days or 4 sessions, in which I'll be detailedly covering those two areas also. So till then, whatever topics we have covered, please make sure that you understood these, you revise them, you recall them, you solve a number of questions, and if you have any doubts, definitely make sure that you get in touch with the Trisha classes so that they will inform me and we can get the doubts resolved. Yes. So till we meet next time, thank you. Take care. Have a good day. Keep studying. Prepare well and do best in the upcoming examination. Thank you. Take care. Have a good day.